Hi, everybody. So I want to get on here and give you an update on my plea and abatement. A while back, I did a live stream talking about my plea and abatement regarding my speeding ticket. And I posted a link in the description. So for those of you who didn't catch that, you can go back and watch that. But basically, my argument um, in that was that my speeding ticket should be dismissed, or at least abated, because I don't own my life, right? I was arguing that the state has enslaved me against my will. I went through the elements. I've talked to y'all several times about the elements of slavery based on Plessy versus Ferguson, that it is a deprivation of the right to life, property, the disposal of one's life, property, and services. So, y'all can go back and catch that live stream again. It's in the description. But I told y'all in that live stream that they were basically going to dodge it, right? Because there's no way they can answer that. Um, they they like these cases to be simple, right? If you're trying to challenge a ticket based on constitutional grounds, then that's reversible error, right? Because I told y'all before about these speeding tickets that they can violate state law, and that is not reversed. That's considered harmless error. But if it's based on a constitutional deprivation, then that is reversible error, right? And so I'm not going to argue for the right to die in a civil case, because, well, there's so many ways for them to wiggle around it. First of all, they're going to claim immunity. So because, and I don't want to get too deep in it, but you can't sue the state directly. You have to sue state actors under 42 USC 1983. You can sue state actors in their individual or official capacity, but they're going to claim immunity, and they have all these ways of getting around it. If I do it in a criminal case, they don't have immunity because they're the ones who initiated it. Um, so I used this ticket as an opportunity to fight for the right to die. And so, like I said, they were going to dodge it. And so the response that I got from the prosecutors was that a plea and abatement only applies to civil cases, right? Because it's listed under, or enumerated under, the rules of civil procedure. But a plea and abatement actually applies to criminal cases too. It's actually a common law remedy. It So they have their criminal complaint, but a plea and abatement um, addresses matters that are outside of the scope of their charge. So I don't have to address. Well, I did. I basically threw everything in the kitchen sink at them, but I can also address matters that are outside of their charge, and say this case should not move forward for XYZ. And so what I'm saying is that I don't own my life. And y'all can go back and catch that live stream. But basically, I'm saying that I'm the state slave. The state owns me, and the state can't sue itself. My property belongs to the state. My life belongs to the state. My services belong to the state. So therefore, I should have absolute immunity. Um, but anyway, let me go ahead and show y'all where we are right now. So I actually I filed a whole bunch of motions, so it's kind of hard to keep track of. I'm not going to update it on y'all because it's a lot. Most people are not going to put this much effort into fighting a speeding ticket, but I'm making a point. So I filed a motion for the appointment of counsel. Y'all know that in misdemeanor cases, you don't have the right to an attorney, right? So I was trying to fight that, but you know what? I guess you can only fight one battle in one case. You can't try to take on a whole system in one case. They denied my motion for the appointment of counsel. So I mean, basically, most people don't have any legal training. They don't stand a chance. So because they denied my right to counsel, I filed a motion to recuse myself, and they can't argue this. I'm getting really better at this. I'm really fine tuning my tactics with them, things that they can't argue against. Here's my motion and I'm going to eventually get back to the right to die, but I just want to. This is a lead in to where we are right now. So here's what I said. Motion to recuse defendant from self-representation comes now. Defendant appearance or jurors. moving to recuse himself from self-representing himself in the above captioned case. I say defendant should be recused from representing himself in this case for the following reasons. Defendant is not smart enough to represent himself. Defendant lacks proper knowledge of the law as well as a lack of emotional intelligence slash temperament to maintain a defense. Now, when I motioned for an appointment of counsel, I argue all this stuff, but they basically still said, "Well, I can go to legal aid or whatever." So I'm just going to say, basically, if there's this is a due process violation. They don't appoint counsel in misdemeanor cases. So fine, my new tactic is that I'm just going to file a motion to recuse myself to say that I'm just incompetent. Um, Defendant is an anarchist who does not respect authority, which it isn't based on consent, but it's based purely on a threat of physical force. All laws are based on physical force or threat thereof, that they're going to throw you in a cage, they're going to take your property, or they're going to take your life through physical force. There's nothing voluntary about it. So to me, it's inherently illegitimate. The tyranny of the majority cannot give consent on your behalf. That's not legitimate. And their consent is based on manufactured consent. They're just programmed. They watch the media. They're brainwashed through education. So it's illegitimate. And we're going to get back to that when I get to my response to their plea and abatement. Um, Defendant is experiencing post-traumatic stress as a result of the court issuing a hit against defendant to have men with guns throw defendant in a cage. And by hit, I'm referring to the arrest warrant that they issued against me. I told y'all that my dad died. So the day after my dad died, I was supposed to go to court for a pretrial. They already had a pretrial hearing, and they're only entitled to one. I filed a motion to recuse. When you file a motion to recuse, gosh, okay, I don't want to get long winded because I know people aren't going to stay here long, and I do want to get into the whole right to die stuff. So hopefully, I won't lose people's attention. But this is the last part I'm going to address, and then I'm going to move on before I start losing people. As a proponent of the Protestant work ethic, defendant's uncontrollable contempt for those who live without working while using the law as an instrument of oppression to siphon wealth from the public is likely to cause the court and the state to retaliate against defendant. Compelling defendant to maintain his own defense imposes an undue burden and involuntary servitude on defendant in violation of the 13th Amendment. Okay, now I'm going to get into the whole right to die stuff. Um, Again, y'all, when I do this stuff, I present novel arguments. This No attorney is going to argue this stuff. So I'm glad that I'm able to represent myself because I think I can do a better job than any attorney. They're just going to take your money anyway. I mean, even if you don't have to pay the ticket, you're going to be paying the attorney the same amount of money or more. So anyway, defendants reply in support of a verified plea and abatement. Come Oh, I'm responding to what they said. They didn't want to address what I said in my plea and abatement. They basically just gave, I think it was maybe two sentences where they basically just said that um a plea and abatement does not apply to criminal cases. Okay, no, you're wrong. You're absolutely wrong. Defendant filed a verified plea and abatement requesting that the court suspend and abate the state's claim until there has been a judicial declaration as to the true owner of defendant's life and defendant's property. The state of Texas has filed a response making the conclusory claim or assertion that defendant's plea and abatement is a civil remedy that does not apply to the criminal citation in question and that a formal response is not required. You can't do that. You can't just say it doesn't apply without giving any citations and then say we're not going to file a response. No, you can't do that. Um, so here's my argument to that bullshit. On October, which I'm not going to give y'all my date of birth, defendant's parents bred defendant into hell without his consent, subjecting defendant to a lifetime of state imposed oppression and capitalistic drudgery. As a natural consequence of being bred into hell, the defendant ultimately became an adult who now is compelled to work in order to survive. Also, as a natural consequence of being bred into hell without his consent, defendant is compelled to travel to his place of employment in order to earn a livelihood. Defendant did not choose any of this, and none of this is defendant's fault. On December 27th, 2023, defendant was driving to work at a reasonable and prudent speed. That's the law. There's no actual speed limit in Texas. You have to drive at a speed that is reasonable and prudent. The speed limit is just a prima facie standard of what is reasonable and prudent, but it's rebuttable. Through the threat of physical force, a road pirate by the name of Officer Jackson (brackets road pirate) bullied defendant into pulling his motor vehicle over for the wrongful purposes of harassment and taking property which doesn't belong to him. The road pirate approached defendant's motor vehicle with a firearm on his hip. The road pirate presented defendant with a blank screen and ordered defendant to sign it under threat of arrest, parentheses, an unprovoked act of violence / physical force in violation of natural law. After being forced to sign a blank screen without being allowed to read it, the road pirate presented defendant with a document titled Citation for the purported charge of speeding. Defendant derives no personal benefit from commuting to his place of employment other than maintaining his life, which actually belongs to the state. The state's speeding charge is pretextual. This case is really about the fact that the state thinks the government is God and is now charging defendant a toll for the privilege of existing, a privilege which defendant doesn't even want. Defendant cannot live unless the government gets its cut. The state is forcing defendant to continue existing against his will while contemporaneously depriving defendant of the very livelihood which defendant needs to survive. The only purpose of defendant's life is to give the fruit of his labor to the state and or to the state's corporations. Defendant is the state's slave. To the extent that the state is able to prove that defendant in fact exceeded the speed limit, said offense nevertheless occurred within the scope of defendant's enslavement to the state and to one of the state's corporations. Parentheses, corporations are fictitious entities birthed and created by the state. Defendant would not exist and therefore could not violate any law but for the fact that the state has deprived defendant of his inalienable right to terminate his life. By depriving defendant of the right to terminate his life, the state has deprived defendant of any meaningful means of opting out, subjecting defendant to a litany of unjust laws for which defendant does not consent. The only basis for the state's authority over defendant, that's a grammatical error, is threat of physical force. It should be defendant's life. Either taking defendant's property through physical force, throwing defendant in a cage through physical force, or terminating defendant's life through physical force. Defendant maintains that any authority which isn't based on defendant's express consent is inherently illegitimate. The tyranny of the majority has no authority to vote defendant's individual and inalienable rights away. The only reason that defendant is required to pay a fine to the state is because the state has a monopoly on the use of physical force. This is a case of economic terrorism, and defendant is defenseless against the state's army of men with guns. The state is effectively holding a gun to defendant's head and forcing defendant to submit to its will or else be killed. If defendant resists being arrested or having his property taken, the state is authorized to use brute force, even to the extent of taking defendant's life. Defendant has no right to defend himself. When defendant missed a hearing due to the death of his father, the first thing the court did was to callously order a hit. I'm talking about an arrest, y'all, but I'm not because their laws are legitimate. I'm not calling an arrest. I'm calling it a hit. These are violent savages, and I don't recognize their authority. So I'm going to call it a hit the same way I would call it a hit if anybody else were to threaten violence against me. The court callously ordered a hit against defendant to have men with guns throw defendant in a cage through physical force. Of course, state actors are permitted to violate defendant's rights with impunity because defendant is a slave who has a unilateral duty to obey without any actual rights enforceable against the state. Now, the reason why I'm saying that they violated my rights is because the court issued an arrest warrant against me while there was still a motion to recuse still pending. You can't do that. When a motion to recuse is still pending, the court can't take any action. It operates as a um it basically stops the entire case. I'm trying to think of why can't I'm going a blank right now. It'll come back to me. A wise man once said that the government comes out of the barrel of a gun. Statism is predicated upon physical violence or threat thereof. All acts of government constitute acts of violence. Defendant is the only actor involved in this case who is nonviolent. As an anarchist, defendant believes that any authority which isn't based on consent is inherently legitimate. Although the court may not view the state's complete control over the lives of Texas residents as oppressive, each individual should be free to choose between living a life in abject subjugation or opting out through a painless and humane death. There is something seriously wrong when dogs and felonious criminals have a right to die, but law abiding citizens are cruelly forced to languish against their will. And then I basically get into their argument or their claim that plea and abatements don't apply to criminal cases. What did I say? Um, an arrest of judgment in criminal cases may be raised by a motion to quash or a plea and abatement. Um, Although pleas and abatement are enumerated under the Texas Rules of Civil Procedure, said pleas actually originated under common law and apply both to criminal and civil case. See, I present novel arguments, so when I make they these people are very um like their arguments are not original. They're not used to when I come up with these arguments, they're kind of thrown off guard because they have their bullet point responses and they can't just copy and paste whatever they used before because I'm coming up with original shit. I don't know. Well, apparently they've never had anybody use a plea and abatement in a criminal case, but you can do it. I have case law saying that you can. Um so here's the case law says that a criminal court may grant a motion to quash which effectively dismisses the indictment or a plea and abatement alleging a violation of the right to a speedy trial. Um And in the context of jeopardy, a trial court may properly dismiss a prosecution with prejudice. Um, and the reason why this is important is because normally the court can't dismiss a case without the prosecution's consent. The prosecution actually has more authority than a judge, except in limited circumstances when it comes to constitutional issues like the right to speedy trial, um, or well, even if they violate the statute of limitations, because I even had them prosecute a case that was beyond the statute of limitations. They filed the original complaint was within the statute limit, but they filed an amendment after the statute of limitations had told, and the court still allowed them to proceed because it was up to they was it was their the it was the prosecutorial's discretion whether to do that. Again, I told y'all that if it's based on a violation of the state law, that's considered harmless error. But it's based on a constitutional violation, that is reversible error. So yeah, the state statute of limitations is harmless error. This law is so corrupt. It's so I mean, even for somebody who actually has legal training, it's still hard to maneuver around it. So, um, where it was a variance or omission in the name of a person injured by the commission of the offense is much more serious than a mistake in the name of the defendant in an indictment, as the latter can only be taken advantage of by plea and abatement, while the former will be grounds for arresting the judgment. Um, I don't know if y'all. Okay, I don't want to get too. I don't want to spend too much time on the legal stuff. The state is forcing defendant to live a meaningless life, and forcing defendant to be miserable in perpetuity, while bullying defendant to submit to a sadistic oppression through threat of physical force. The state solution is to make everyone miserable and then force them to undergo counseling and take pills in order to cope with its oppression. Of course, the real solution would be for the state to leave everyone alone and stop making everyone miserable in the first place. Defendant maintains that to the extent that the state is able to prove, in fact, that defendant in fact exceeded the speed limit, said offense occurred within the scope of defendant's enslavement to the state and to one of the state's corporate entities. Defendant would not exist and therefore could not violate any state law, but for the fact that the state has deprived defendant of his inalienable right to terminate his life and is currently forcing defendant to exist against his will. By depriving defendant of the right to terminate his life, the state has deprived defendant of any meaningful means of opting out of the state's oppression, rendering defendant a sitting duck to be oppressed in perpetuity, and subjecting defendant to a litany of unjust laws for which defendant does not consent. The state has imposed an illegitimate and unilateral social contract on its residents, in which Texas residents are required to obey the law, but state actors are effectively parasites who are above the law and only use the law as an instrument of oppression to engage in economic terrorism, siphoning wealth from the public while producing nothing. The only basis for the state's authority over the defendants. I think I copied that. Let's skip through this. Um, so they're saying that it's a plea amendment doesn't apply to criminal cases. Well, um, criminal cases are, excuse me, criminal proceedings for offenses punishable by fine only are quasi civil in nature. Now, this case that I'm citing is from Kentucky, so it's not binding law, it's persuasive, but I mean, I think everybody knows that. Um, Crimes punishable by fine only are quasi civil. So it's not like a regular prosecute. It's not even held to the same due process requirements. So I mean, they're trying to have it both ways. You don't get the full due process protection that you would get in a felony case. So yeah, it's quasi civil. To the extent that the court determines that a plea and abatement does not apply to criminal cases, the court should treat said plea as a plea to the jurisdiction and issue a ruling on the underlying issue of whether the defendant's lack of ownership over his life grants him immunity from crimes punishable by fine only. The state's refusal to file a substantive response should be regarded as a waiver, and the court should issue a ruling in defendant's favor. So here's my prayer. The court should abate this proceeding and order defendant to receive a mental health evaluation to ensure that defendant does not suffer from any psychiatric disorders. Upon said evaluation, the court should put defendant on a 1-year waiting list and then allow defendant to hire any person of his choosing to terminate his life, granting said person immunity from prosecution. By the way, I wanted to do content talking about the law in Canada. Um, I don't know what you. I mean, I'm so sick of the censorship, but without me giving my personal opinion on it, in Canada they actually have legalized physician assisted S word. Um, or I just let me call it what it is. It's death with dignity. Like let's use the proper term for it. They have legalized death with dignity, but there is a 2-year waiting period, and there are no limitations for it. So you don't. It doesn't have to be for a terminal illness. It doesn't have to be. You don't have to have any justification whatsoever. You get put on a 2-year waiting list, and then after that 2-year waiting period, then you can come back. A lot of people, I would like to do a full video discussing that, but I know YouTube is going to censor me, and I've already had my account um deleted. So I'm not going to take a risk talking about that because what I would say probably would not fly. Um, this is the only way to guarantee that the defendant will not violate the state's unjust laws. If the state objects and continues to force defendant to live against his will, the court should grant defendant absolute immunity from all crimes punishable by fine only. Alternatively, the court should order the state to pay for defendant's living expenses so that defendant will not be put in a position of inadvertently going over the speed limit while commuting to his place of employment. At the very least, the state should be compelled to state its basis for subjecting defendant to unjust laws other than manufactured consent by tyranny of the majority. Okay. Um. So let's see if anybody. Oh, I still have some people here. Yeah, I'm sorry that we're stuck in this realm. Also, um. So they didn't want my smoke, right? They didn't want to have to follow a substantive response to what my argument was, because although the municipal court doesn't necessarily have the right to grant me the right to die, once it goes on appeal and then it gets to in Texas, we have the Supreme Court, and then we also have the criminal court of appeals, which they're equal. So the criminal court of appeals has just as much as authority as the Supreme Court. This would go if I appealed it all the way up and argued this as a constitutional issue, then they could rule on the issue, and then whatever ruling they give is appealable to federal court. So if they denied me the right to die, and they what I mean it basically, like I said in that last live stream that I did about this, they were backed into a corner. They can't say that I'm a slave and I don't have a right to die, because that violates the Constitution. They deprive me of my right to life without due process of law. Um, so their response was basically, we don't have an argument, so we're just going to dismiss this case. Now, their claim, the prosecutor called me earlier today, and what he said was that because I filed a whole bunch of stuff, I filed a motion in limine, and in that motion in limine, I said that they should not be able to present any evidence because they have not shown that there was a proper engineering um traffic investigation. Basically, unless they conduct a study to determine the speed or traffic flow, and these engineers come out and it's all sophisticated. They're supposed to present all this evidence before they post the speed. They can't just post the speed limit arbitrarily. They have to do an engineering traffic investigation, and if they don't do that, then the speed limit is void. That's how they determine the speed limit. So I think they actually did conduct an engineering traffic investigation, but in order to save face, because they couldn't argue against my plea and abatement, they're going to say, "Oh, we made a mistake." That's what they literally said. There was an error in the zoning of the traffic of the speed limit, and they're saying that they didn't conduct a an engineering traffic investigate. That's bullshit. I believe that they did, because well, either they did or they're running a scam, because that's not a mistake. They either knew that they did not do an engineering traffic investigation, and if they didn't do that, then they can't post a speed limit without doing that. So I feel like it was an excuse in order to get around this whole plea and abatement. They didn't want me to be able to argue this and fight for the right to die. And I've also filed um, complaints with the Bar Association against the prosecutors. I filed 3 ethical complaints against judges. Um, so because I told you I missed the pretrial hearing because of the death of my dad. Um, but there was a pending motion to recuse, so they can't take any action. But what they did is they issued an arrest for my warrant for my arrest, and they also issued a judgment against me without a hearing, without any notice. They can't do that, right? So they basically fucked themselves because they were so emotional. They wanted to get even with me. They basically just fucked up their own case. Not that they. I mean, what is their interest in this case anyway, other than taking my money? But it's almost like they feel so aggrieved that they were not able to take my money. So I don't know. There was a person in my comment section who kept talking, who basically being a hater, talking shit, said that I don't have any litigation skills and I don't know what um I'm actually getting pretty good at this shit. And it's not even like I'm not trying to be arrogant. I've gotten better over the years because the shit that I was doing before wasn't working. I would put in so much work doing all this shit. I would put in hours and hours writing all these damn motions, and I was not getting the results that I. Now I think I have a better idea of what works and what doesn't work. So, um, I don't think any attorney can do any better than what I'm doing right now. Um, they basically had a solid case against me. There would they in terms of jurisdiction, they did everything right, and yet I was still able to get this ticket dismissed. So, I don't think an attorney could have been able to do this because they would not come up with the novel arguments that I'm presenting. So, um, I'm going to go ahead and get off here, but I told you I was going to update y'all on that, and I'm sorry. I would like to fight for the right to die. Maybe there'll be another opportunity for me to do that, but this case is not going to be the vehicle for me to do it because they were cowardly. They didn't want to go toe to toe with me and actually, you know, present an argument. They would have to admit that what they're doing is slavery, and they would have to grant us the right to die. So, they don't have an argument. They know that they probably didn't realize it before, but when I laid it all out, yeah, they know this shit is bullshit. They know that they're violating the Constitution. So, um, and okay, I'll say this last little thing. The only reason why this case will never, or a similar case will never see the light of day, there's not going to be anybody else who's going to present this argument. First of all, who's going to argue for the right to die? Who's going to be able to afford to hire an attorney to do this? And who would pay an attorney thousands of dollars to argue this in a speeding ticket case? It's not going to happen. So the likelihood of somebody in my position of having the knowledge to be able to do this, very slim. So I'm going to go ahead and get off here. I'm already, yeah. So I hopefully I'll be doing another live stream soon. I do have other topics, and I will hopefully be doing more content on anti-natalism. Y'all have a good night.